Now let's.
Good.
Oh yeah.
I had a judge ask me how much my fee was during the hearing. Is that typical?
Absolutely.
Should be
Well,
disclosed.
it depends on. Were you representing a debtor or a trustee
Why don't
or a
you
secured
repeat the
creditor?
question for the tape, Judge? Judge.
Oh, the question was you were asked how much your fee is as part of a hearing. You were representing a debtor. What's surprising about that is you should have been retained, but not in every situation. It depends if a Chapter 7 debtor is trying to save a home. Maybe they're not getting court approval. You're getting court approval. Let me back up and I'll answer your question. You're getting court approval if you expect to be paid out of the bankruptcy estate. See, the benefit of a bankruptcy estate is that all of these professionals look to get paid from it. So not only is the debtors' counsel and accountants and appraisers and auctioneers getting paid, the trustees' professionals are getting paid. If there's an unsecured creditors committee, those professionals are getting paid all out of the estate, which means the debtor's assets. And if you're going to be paid out of the estate, because payment to you means less money going to unsecured creditors at the end of the day, I need to know. But if you were being paid outside of the estate by the debtor, maybe, it would not necessarily be that you had to be retained, but it's certainly relevant on a number of scenarios. Now, what I'd like to point out is getting your retention approved by the court is not the end of the day. You still have to actually submit an application to be paid, because you may have been given a retainer and then still awaiting funds, or even if you were paid in advance. Here's the shocking and sometimes disappointing element for professionals. The bankruptcy court can order that you not get paid, or that you disgorge the fee if there was some wrongdoing. Or you're waiting to get paid out of the bankruptcy estate, and here's the problem. There's no money. The asset didn't sell for what everybody thought it would sell. The house, the commercial office building, didn't have the equity everybody thought. So the trustee's not getting paid, the trustee's lawyer's not getting paid, and the trustee's professional or the debtor's professionals aren't getting paid. You've done the work. Maybe you got some upfront money as part of a retainer. But at the end of the day, until I issue an order approving your fees, and there's money to pay those fees, it's not a sure thing that you're going to actually see the money and get paid. And it could be frustrating. And what I've seen, and it's always surprised me, and it's a good thing for you all, at the end of the day, in most Chapter 7s, and I was a 7 trustee for many years, and I look in cases that turned out what we'll call administratively insolvent. Not enough money, forget paying unsecured creditors any money, 10 cents on the dollar or 5 cents on the dollar. At the end of the day, there wasn't enough money to even pay all professionals in full. Professionals had to be paid pro rata. But yet, there always seems to be certain professionals that manage to get in and get out and get paid. And it's the auctioneer, who I won't name, and the appraiser. Because it's usually a small sum, $1,500, $2,000, whether it be a real estate or a personal property appraiser. The work was done early on in the case. The appraiser's done, submits an application, a fee application, shows the court order that approved his retention in the first place or her retention, came in, gets done, somebody cuts a check early on. It's only 2.5 years later, at the end of the case, they realize that there's no money to pay the trustee's commission, the rest of the attorney's fees. Rarely, if ever, do I see the judge being asked to go back by the trustee. Tell me how often you've done it. Say, let's
never.
get back. There's a mechanism in the code to have all the professionals disgorge what they've gotten, talking about keeping what you've been paid. There's a mechanism to say, well, everybody has to receive pro rata. So if you got paid 2 years ago in full, and these professionals have worked this case for 2 years, and they're only getting 70 cents on the dollar, you kick back 20%.
I can tell you, as trustees counsel, that almost never happens because the trustee needs an appraiser in the next case, needs an accountant in the next case, and is not going to find one if the trustee is disgorging fees just so the trustee and his professionals can share in those disgorged fees.
But 2 follow-ups. I feel like we're in a town hall debate session. What's your name? I want to say loud. Dave. So, Dave, there's two things in that, going back to what the judge and...
As long as Mike is not Candy.
All right.
We won't go there.
Did you use the word terror? So the issue on that was that the reason that I think it is totally fair and appropriate, putting aside bankruptcy, it's always relevant cross-examination for me to ask what you got paid, because it may or may not, depending on what the number was, go to, but.
And the source of payment,
Okay.
even
Well,
more critical.
That is.
Unreasonably high, they would suspect that.
Exactly.
you're not-
That it might have affected your result.
unbiased.
Dave. But the other part of it, to go back to the concern that the judge and Dan are raising about your risk, because of course, you know, if you were at risk of having to either not get paid or cough up your money, then you would rather come to seminars like this and listen to, you know, hot air. But I guess the point on that is, if you disclose in the paperwork that the debtor's principal, for example, of Crown Plaza, that it's not, the money's not gonna come out of Crown Plaza, but it's gonna come out of the principal, and if the judge approves it up front, then the good thing is you can have him or her guarantee your engagement or pay your engagement, and then you're protected. You don't have to worry that the estate becomes administratively insolvent and you get, you know,
Well,
shut
that
out.
was my next question is, in a person, in a personal bankruptcy, the person really could not pay you directly, right?
Well, yes, no, maybe. The short answer, Dave, so the question is, in a personal bankruptcy, can the chapter 7, we're gonna use 7. 7 is a liquidation, as the judge said. You file bankruptcy, you're looking for a discharge, you put everything figuratively on the table, and you look to wipe out your debt. And the question Dave's asking is, how does a debtor in that case pay an appraiser for service? So, if a debtor has a job and works post-petition, and so it's not property estate. The estate, as the judge said, is magically created
Certain date,
as of the date you file the petition. Then arguably, under that scenario, if it's not coming out of, you know, his pre-petition or her pre-petition bank account, it's all, it's okay.
Let's give an illustration. Let's say the trustee wants to sell the debtor's house.
Right.
And because the trustee believes there's equity. And the trustee has retained an appraiser to go by and tell him or her what the value of that house is. Now, the debtor went into this bankruptcy. He spoke to his bankruptcy lawyer. The bankruptcy lawyer said, don't worry. The trustee will abandon the house. When you take the liens against the house, you add it to your exemption. There's no equity. Don't worry. The trustee will abandon. Well, suddenly, it's not happening. The trustee is looking to sell. Debtor is upset. Debtor wants to contest, to object to the trustee's efforts to sell that house. Debtor needs to show that, no, the trustee's appraiser is wrong. There isn't that equity. So the debtor needs to get their own appraiser. At that point, the debtor doesn't need to get court approval because that money's not being paid out of the estate, nor is the appraiser for the debtor at that point a professional of the estate. The debtor in that case is not in a Chapter 11, a debtor in possession is not working for the benefit of all creditors. The debtor is working for the benefit of the debtor and can be paid by the debtor.
Under the judge's scenario, though, the appraiser who is being retained by the trustee would need to be retained with
Right.
approval of the bankruptcy court. And mechanically, whoever is retaining you in a bankruptcy case should handle the application to the court for approval of your retention and should also handle filing the fee application. And what you should really be asking for is for that professional, be it a trustee, debtor, creditors committee, whoever has retained you in a case, to get your fee application filed right after you do the work. Okay, you don't want to be, in a bankruptcy case on a contingency. Once you've provided your appraisal, you want to go to your professional and say, file my fee application. I want to be paid now. And
Question?
that's normal.